Assalamualaikum and hello everyone. We are from BA195F. For today, we would like to share one of the law case and the subject legal aspect and ethics banking, which is case Great Western Railway Co. versus London and Country Banking Co. Limited from Chapter 1. So, first of all, let me introduce our group members.
Hi, my name is Nurul Maisara binti Sujai.
My name is Rajin Fazira binti Raja Azrin.
Hi, my name is Nurul Fatihah binti Zakaria.
Firstly, I will explain the facts about this case. There have a man acquired a check payable to his order from the appellants under false pretenses, gross generically and marked not negotiable. And for several years, a man had been paying checks over the counter at the defendant bank, where they were received in good faith and cash, with a portion of the profits being held by the bank for a customer's account and the remainder being given to him. So, the case now is whether he is a customer at the bank.
Next, what is the issue in this case and why? It was held that a person who for about 20 years had been chasing a bank check payable to him over the counter without opening an account with the bank is not a customer of the bank. Next, it is also necessary that the account concerned was opened in the name of the supposed customer either by himself personally or by some other person with his authority to do so. These cases was related from Chapter 1, which is a basic contractual relationship. There is no statutory definition of a bank customer, and therefore, it is necessary to rely on case law in order to establish whether a person is a customer or not. In Great Western Railway vs. London and Country Banking Co. 1901, it was stated that a customer must have a current account or deposit account or some similar relationship. However, not all customers of banks deposit money and may, for instance, deposit valuables other than money. Yet, the banks regard such people as customers. To make the audience understand better, I will explain about definition of customer under the common law. First, a person who has an account with the bank and it can be either saving or current account. Second, a person must have some form of account with the bank to be a customer.
Moving on to court held under Section 82 of the Bills of Exchange Act 1882. For a person to be a customer of a bank, he must either have a deposit or a current account with the bank, or there must be some entry of debit or credit in the bank's book or papers relating to his transactions, or some similar relation must exist. And applying this test, he was not a customer of the bank within the base on Section 82 of the Bills of Exchange Act 1882. In this situation, the bank did not receive payment of the check from him under Section 82 because the money in respect of the check had already been given to him in exchange for the check. And so, the money received by the bank when the check was prescribed was received from the bank's own account for reimbursement, not for him. He never had any title to the check, and because it was marked not negotiable, the bank could not acquire a better title to it than he did under Section 82 of the Act, and the bank's title to the money received in exchange for the check was as defective as their title to the check itself. Thus, the appellants were entitled to succeed and the bank was not entitled to the protection of it. To simplify, plaintiff sued him to recover the value of the check. The substantial question arose was whether he was a customer or not. The court held that as there was no sort of account, he was not a customer of the bank, because a person is a customer only if he has an account with the bank.